Good afternoon. Welcome to the juvenile record sealing training provided by Team Child. I'm George Inakis, and along with Andy Savino, we'll be doing a training. We'll be using a PowerPoint, some video, and then we'll be doing some role plays. I'm an attorney. I work in Seattle for Team Child, and I've been at Team Child now, it must be 4 or 5 years. Before that, I was a public defender in Seattle. I worked for Society of Counsel and for the Defender Association. And I don't want to tell you how many years I worked because it's sort of embarrassing to me. And I've been doing a sealing clinic. I taught at Seattle University in their clinical program, and we started a record sealing clinic there in 2004 after the legislature expanded the scope of, or the range of people who could have their records sealed. And we started the clinic at Seattle U, and we then moved the clinic 2 years later to Society of Counsel, SCRAP. And Kim Ambrose, a professor at the University of Washington, and I have been the supervising attorneys there. Well, a year ago, Team Child got involved in the clinical program, and they forced us to be much more strategic than we'd ever been in thinking about the clinic. We sort of just, every month, we'd send out a notice to volunteer attorneys. We'd rely on Law students from Street Youth Law, Advocates of Washington, student-run programs at the University of Washington and Seattle University to get our student volunteers. Well, Team Child's forced us to be much more strategic. So as part of that, we actually applied for a grant to expand record sealing clinics throughout Washington. And we were successful in getting it, and we were able to start a clinic in Skagit County, Mount Vernon, near Seattle, and hopefully we're starting one soon in Thurston County, Olympia. And then Lindsay contacted me and said that the Thomas More students here at Gonzaga were interested in doing it, and we said, well, we'll be out here to do the training. We'll be out here to help you in any way we can. So we're here today, and we're going to do a training, and hopefully the training will take about an hour. It depends on who's been doing it. Sometimes Kim Ambrose, who does this a lot, speaks so much faster than I do that she can whip through this easily in an hour. That may take a little longer. And then I thought we'd try to do some role plays as to how you do interviews and how you use the computer to generate our forms. So let me just start. Did I introduce Angie? Angie Savino is a 3L at Seattle University, and she is we hired her as an intern in the clinic, and she's been doing the work now. This is your second year, third year that she's been doing it. And she knows this stuff much better than I do, and that's why she's here today. And Angie will be talking more on the technical aspects of how you can use the programs, the computer websites to generate forms, and how the clinic actually runs. So let's see. I'll show you how limited I am in this. Okay, so we have goals for today's training. Understand how the juvenile criminal history affects people's lives and into adulthood, which is the reason why we're doing this, because it really impacts, the impact is surprisingly large. Learn how juvenile record sealing clinics run and how you can participate. Gain an understanding of the juvenile justice system and some basic crimes. We're going to do that real quickly. Learn how to interview a participant in the clinic. Learn the requirements for sealing a juvenile record. And learn how to fill out the forms and assist a person in sealing their records. So our clinic and the model we've been using is a pro se clinic. Attorneys, students don't represent the former juvenile offenders who are seeking to have their records sealed. So today I'm going to refer to them not as clients, but as pro se clients. And if I make a mistake and call them clients, please someone call me out and let me know that I made a mistake. They are not our clients. We don't represent them. We help them fill out their forms. We help them file their forms, but it is it's pro se. We don't go to court and advocate. If there's ever a dispute, if the prosecutor says, or some agency objects to the sealing, we strike the hearing and we then link the former offender, the pro se client, with an actual attorney who then would argue anything. So everything we do at the clinic is pro se. Why do we do this? Well, in Washington, individuals with juvenile criminal history struggle with getting a job, getting an apartment, participating in school programs, especially for credentialed programs, nursing, cosmetology, dental assistance, participating in their children's field trips, getting into the military, getting licensed to provide child care, foster care, or adopt a child. How does a juvenile record impact this? It can bar you from being able to participate in some of these programs. Given the choice when you go to apply for a job, if there are multiple applicants, who's going to be the one that's first removed from the recruitment pool? It'll be whoever has the juvenile record. How long will a juvenile adjudication stay on the record? In this marvelous age of technology with the internet, juvenile records will last forever. As long as there's an internet, juvenile records will be there. Unless you're eligible and you seal your record, affirmatively seal your record. They don't just disappear. You must file a motion to vacate or seal the conviction in juvenile court, and the court must grant your motion, and you serve the order sealing your record to all the agencies that had your record. So if you get arrested, the arresting agency keeps a record of your arrest. The juvenile court will keep a record. The prosecutor will keep a record. Washington State Patrol will keep a record. If you get to a juvenile institution like Echo Glen or Green Hill, the juvenile prisons, they keep a record. So until you let all those people know, your record's still public. Here are the myths. Juvenile records are never expunged. That word is used in Oregon. It's used in, I think I found it in Idaho. Expungement means it's eradicated. We never expunge records in Washington. We seal them. And the reason we don't expunge them is if you have a sealed record and you later commit a felony offense, your record becomes unsealed. So it stays, but it's not visible. One of the biggest myths is, and your record, when you turn 18, your record goes away. Or when you turn 23, it goes away. And to be honest, when I first started practicing in juvenile court, that was the law. Misdemeanor records were sealed or eliminated or expunged when you were 18. Felony records were expunged at age 23 unless you committed another offense. So there's a whole generation of former offenders who honestly believe, because they were told by the judge and their attorney, that their records have gone away. Unfortunately, when the law changed in 1997, no one told those people that their records were going to be available on the internet. So now we get people who are applying for jobs at Boeing, they're in their 30s or their 40s, and they're coming back and saying, you know, I've got this juvenile record and it should have been eliminated because they never got in any more trouble. And the judge told me that. And yeah, the judge did. Unfortunately, the legislature didn't take that into account when they changed the law. So these records are now appearing after not appearing for years. And juvenile records are accessible to the public just like adult criminal history. You can all look at it through the Administrative Office of the Court's website. It's all there. You can get it through the Spokane Juvenile Court website or the Spokane Superior Court website. It's all there. Must be disclosed on employment and other applications. Well, you know, juveniles don't get convicted. Juveniles get adjudicated. Now, this is another law change that has gone back and forth for let's see, 25 years, juveniles were only adjudicated. Then in 97, they decided, no, they've been convicted, and then just a few years ago, they changed it back, and juveniles are only adjudicated. Well, what's the difference, right? The semantics. And if you're an employer and you're saying, you fill out your form for an employment, and they say, have you ever been convicted of a crime? And you say, no. And then later they run that employment check, and you haven't sealed your record, and they see that there's a juvenile adjudication. Do you think that really makes a difference to a potential employer, to a landlord? I don't think so. What was that last one? It said public defenders will not seal your records, right, Megan? Is that part of your contract? No. Is that within your scope of employment?
No.
No. So even though even though the judge told you, okay, if you stay out of trouble when you turn 18, you can have your records sealed. Okay, who's going to do that for you? Your public defender won't, because it's not within the scope of their employment contract. The court won't appoint an attorney for you because that costs money. So you have to do it on your own. And what we're here today to do is help you learn how to do this for former offenders who can't afford to do this on their own. Now, in Spokane, we'll talk about this a little bit more, there's a wonderful service by the juvenile court. For $100, you could go to the juvenile court and they will seal your records for you. And the prosecutor, I've talked with the prosecutor, once they're approved by the juvenile court clerk, he will sign it and get the order signed off, and it's all done for $100. Well, that's a pretty reasonable amount, really. You know, if you go to a private attorney, is that one of my, there it is. Spokane will seal it for $100. If you go to a private attorney, it could be anywhere from $300 to $1,500. If we were in Seattle, I would have raised that $1,500 to $3,000 to seal a record. But there's no place for people who can't afford that $100, the ones who are trying to get that job at a fast food or trying to get that housing through public housing. There's no place for them to go. And that's probably who we will be serving here in the clinic. Because if you have the money, you're probably going to pay an attorney, or you're going to pay that money to juvenile court and get it done. We're going to be dealing with people who don't have that money, who probably have a bigger need to get this sealed because they've been barred from employment or barred from housing because of their procedure. Now, Spokane is the only county we found in the state that charges a fee to do it. Is there another one that does it? Okay. It's the largest county we found in the state. King County, Snohomish County don't do that. If you come to them, they'll give you a list of names of private attorneys who might be willing to seal your record. There are a few counties that the probation department, if you had a good probation officer, they may be willing to do it for you. But for the most part, people are left on their own. Anyone have any idea how many juveniles, other than Megan, how many juveniles appear in court each year in Spokane County? How many records are generated? Every time you go to court, there's a file on you. Whether you're guilty, not guilty, charges dismissed, that record exists electronically and is available to the public through the public website. How many kids go up to juvenile court? Michelle?
Around 2,000.
Pardon me?
Around 2,000.
Used to be that high. It's down to about 1,000, a little over 1,000. Statewide, about 16,000. So each year, there's over 16,000 records generated and placed on the web, on the World Wide Web for everyone to view. And it doesn't matter whether you're charged, whether you were found guilty, whether you're found not guilty, whether the charge is dismissed, whether it was whatever, any way it ends, it's there and you have to seal it. Because, again, when an employer is looking at your record, what do they see? They see charge, okay? They see theft in the 3rd degree, and you were found not guilty of that. But but it appears there. The theft charge appears, and that's really where it's going to make a difference. So where's juvenile? It's found in electronic or paper files at the courthouse. The smaller, you go to Lincoln County, you go up to Stevens County, they're there in the courthouse in a paper file, you can go up and look at it. But they also send all that material to the administrative office of the courts in Olympia, and they promptly put it up on the website. What we'll be using, and we'll talk about this a little bit later, you'll actually see what's called a juvenile JIS link, judicial information system run by the administrative office of the courts. This is available to the public, and the Washington State Patrol also has a website, and you can look on their website to see what criminal history exists. The police departments keep it individually. They don't put it up on the internet usually, unless you're a sex offender. And the Juvenile Rehabilitation Administration, JRA, which runs the 4 juvenile institutions in the state. And the major credit reporting agencies, they subscribe to JIS, and they buy our juvenile records, our adult records. They buy everything, and they get a computer dump every quarter from the administrative office of the courts, who sell the records to these major reporting agencies, who then redistribute it freely to other agencies. I mean, you can get all this information if you have access. Do you guys have access to LexisNexis? Right? You get the student Lex. If you go there to the people search, you can find criminal history. Where does it go? So, different places that it goes to: courthouses, private companies, Washington State Patrol, Federal Bureau of Investigation gets everything, the internet, and Juvenile Rehabilitation Administration. And here's where the credit reporting bureaus make some money. They redistribute the records that they buy from our Office of the Administrator of the Courts that these companies couldn't get. Now, these companies are private record searching companies that you go to if you're a landlord, you're about to rent your house. If you're an employer, you want to do a credit check on your client, you go to these places. And these are all on the internet. And you can do it for $10, $20, you subscribe, and they will find all the public records. And they get those records by getting it redistributed freely, or redistributed from the credit reporting bureaus that we distribute this stuff to. A little bit too technical, but it is a problem. So in Washington, who's a juvenile? So I'm saying 12 to 17, but it's really 8 to 17, isn't it? Right? So up until 12, there's a presumption that you can't commit a crime. And that has to be the presumption has to be rebutted by clear, cogent, and convincing evidence by the prosecutor. So usually we don't get kids under 12. Occasionally they are. So 12, if you're 18 and you commit a crime, if you're 18 in one day, you commit a crime when you're an adult. Any youth may be transferred, or what we call in our state declined, to the adult system if the judge decides. And here's a quick preview of the juvenile justice system. You have arrests. If it's your first offense, you get automatically diverted unless it's a felony. If the prosecutor files a charge, we call it an information. As soon as a charge is filed, an attorney is appointed. If you can't afford an attorney, one is appointed for you. And after you get an attorney, you have an arraignment where you enter a plea. Some counties have something called a case scheduling hearing. And then you get down to deciding whether you're going to plead guilty or go to a trial. And if you're found not guilty, then you get out of the system. But if you're found guilty, you go to sentencing. But in the juvenile system, we call it a disposition. And we'll talk a little bit more about what the possibilities are as far as dispositions. Now, if you're, some examples of juvenile crime, probably the most common, of course, is shoplifting. Shoplifting's theft in the third degree, taking property. And what's the due limit now? 750?
Anything over that is felony.
Yeah. So it used to be $300, but that didn't make much sense because you'd go into Nordstrom's and you take anything and you were over $300, so they raised it up to $750. So anything under that's a misdemeanor. If it's your first and only offense, the matter must be diverted out of the system. No charges are filed. Everything's confidential. You enter into an agreement with a diversion board. If you complete that agreement, your record never is made public, and after you turn 18 or 2 years, it's automatically, and it's the only thing that's actually destroyed. So it's for misdemeanors, first time. Macy's. So the first misdemeanor, mandatory diversion, letter from the prosecutor telling you to come to appear in front of the Community Accountability Board, and you enter into a diversion agreement. Complete the agreement, no charges are filed. One free shot, one free chance. But if you fail to complete, the diversion can be terminated, and the prosecutor has the discretion to file the charge. And then you generate criminal history. Prosecutor can either re-divert it, or if it's just, then you get into guilty. Your second misdemeanor, still eligible to divert, prosecutor's discretion. If charges are filed, they go through an arraignment, clear fact-finding, guilty, not guilty, dismissal, and then disposition. If it's a misdemeanor under Washington law, we are the only state in the union that has a determinate sentencing scheme for juveniles. Every other state commits you until age 18 or age 21, no matter what you're found guilty of in juvenile court. Washington, we have a different system. You can get up to 30 days in detention for your first misdemeanor. You can get up to 12 months of supervision, $100 for your victim penalty assessment, and any restitution you owe to Macy's or anyone else. Now, in this packet, which is entitled Volunteer Instruction Packet, we'll go over it a little bit more later. There is the actual determinate sentencing scheme, the sentencing grid for juveniles in Washington. We're the only state that gives determinate sentences. Everybody else, you stay at an institution until you have been rehabilitated or reach age 18 or 21, depending on your majority. In Washington, if you're sent to a state institution for a range, you will spend the minimum time there, that's as soon as you can get out, no matter how good you're doing, and no matter how bad you're doing, you're going to get out after 52 weeks or 56 weeks, and there's no discretion. So it's a little bit different. Everybody else tries to rehabilitate you. Washington, we sort of house you. So another example, we talked about a misdemeanor of theft in the third degree. One of the more common, assault in the fourth degree, schoolyard assaults where there is an infliction of grievous bodily injury. And again, that is a misdemeanor. Assault in the third degree is a felony. Assault in the second degree is a felony with grievous bodily injury. Assault in the first degree is when you use a weapon and assault somebody. So here we have the schoolyard fight, I guess, being broken up by the police or SROs, school resource officers. And here we have a bus driver. If you assault a bus driver, a school teacher, it's an assault in the third degree. And then probably the other most common juvenile offense that is a felony is taking a motor vehicle without owner's permission. Now, I was just at a conference on the school-to-prison pipeline last week. School-to-prison pipeline, schools are pushing, there's a belief that schools are pushing kids out of school, and when they're out of school, they're more likely to end up in prison, and it's disproportional. The director of one of our state agencies got up there and talked about how difficult it was to get his son charged with taking a motor vehicle. Whose motor vehicle do you think the kid stole? Dad's. Dad's car was stolen, and his dad, who was he's the superintendent of public instruction in our state, was telling us how hard it was to have his kid arrested for this felony. Now, why do you think the police might have been reluctant to arrest the kid for a felony? Because the police know it's going to be on his record forever. They don't, it's Dad's car. There wasn't any damage. So, but it is a very, very common offense. But it's a felony, and you have to seal the record, or it stays on your criminal history forever. So other common juvenile crimes: robbery in the second degree, come out of your starter jacket. Hey, I really like your shoes, man. Give me your shoes. Robbery in the first degree, I'm holding a gun and saying, hey, come on, get out of your shoes. Malicious mischief, graffiti, common malicious mischief. VACSAs, violation of the Uniform Controlled Substances Act. What's a possession of heroin, possession of methamphetamines, delivery, marijuana, cocaine, all felonies except for marijuana. And here's the language. Am I going to be able to get to this? So adjudication versus conviction. They're the same but different. So how am I going to get to this? Oh, I can just click on it. All right, one more. Okay. In our wisdom, now the legislature never writes things easily, right? So what do they say? I don't think you can quite read that. Up until this revision in 2010, so up until 1992, that first sentence read, and a juvenile adjudication is not the same as is not a criminal conviction. Then in 97, they said, oh gosh, that's really not what we meant. We mean, we really want to come down hard on kids. So a juvenile adjudication is the equivalent of a conviction. And then in 2010, they said, well, we really don't want to be that hard on kids. It's different. Kids shouldn't have to be held to the same level as adults. So they said adjudication has the same meaning as conviction in RCW 994A030, but only for the purpose of sentencing under that chapter. That chapter is the Sentencing Reform Act for adults. So juvenile criminal history counts as a conviction when you're getting sentenced as an adult. But other than that, it doesn't have the same meaning. So when you fill out that application for your job, and they ask, have you ever been convicted of a crime, you can say, oh, no. RCW 1304-011 says they're not the equivalent. We'll talk a little bit more about what that actually does. But, so can I just go here? No. Okay, so to get back to the PowerPoint, I push. Okay. Thank you. No, I should have gone. Apologize for that. So, sealing juvenile records. There's a statute that specifically seals juvenile records. There's an equivalent statute that seals misdemeanor records for adults, but nothing that does this for adults. There's nothing that seals adult criminal history. There's also one other provision that we're not going to talk about, but it does appear on the form, and that's the Supreme Court promulgates rules of procedure for all our courts, for Superior Court, for Juvenile Court, for district courts, courts of limited jurisdiction, rules on appeal, rules for professional conduct, which probably if you're, how many are 3Ls here? Have you already taken rules of professional? What are they?
With a rule of professional conduct. They govern how we're supposed to act as lawyers.
Right. And these are all promulgated by the Supreme Court. They also promulgate General Rule, and General Rule 15 deals with destruction, sealing, and redaction of court records. So if you're not eligible to seal your record under 1350, the juvenile statute, you can try to seal it under GR 15. GR 15 has a lot more requirements than the juvenile court does, juvenile rule does. It's a lot more difficult, but adults who can't seal their records because they don't have a statute often try to seal under GR 15. The only other way to seal juvenile records is to get a pardon by the governor. We could probably count the number of pardons that Governor Gregoire has given out in 8 years. I used to say one hand, I think it's up to 2 hands now. So that's really not an option, but it is available. Pardons are governed under RCW 994A. What juvenile records can be sealed? Well, up until 3 years ago, you'd have to tell your client if they had been convicted of a Class A felony or a sex offense, whether it was an A, B, or C sex offense. So Class A felonies, robbery in the first degree, assault in the first degree, murder. You'd have to tell them that they couldn't seal their record. You could never seal your record. So there's a whole group of former offenders out there who were told by the judge and by their attorneys that their records could never be sealed. Well, that changed in 2 years ago in the legislature, 2010. So now you can seal Class A felonies. You can seal a murder charge if you're convicted as a juvenile of murder, which there are very few, but you could. And you can seal sex offenses, which there are many juvenile offenders who have sex offenses who were told that you can't seal them. Did the legislature or the courts or anybody tell the former offenders that they can now seal their records? No, but hopefully Michelle's out there telling everybody, letting everybody know that we're now eligible to do that. So you can seal all your juvenile records as long as you meet the requirements of RCW 1350. You also have to seal non-conviction data. So when you went to court and then it was found out, oh my gosh, it wasn't you, it was my sister who did that, she used my name. Well, your name is still on the internet. It's still on the court records. There is a provision to allow for mistakes. That really wasn't the best example. But if you had gone to court and it was found that you were tried, you were the right person, but you were found not guilty, that would still appear. Case was dismissed, that would still appear. Non-conviction data. If you were simply arrested and no charges were filed, there's a court record of your arrest. That's got to be sealed. Court records, police records, JRA and probation records, juvenile sex offense records where the respondent has been relieved of the duty to register, except for 3 types of offenses. So now all juvenile records, all non-conviction data, everything can be sealed except for rape in the first degree, if you were convicted of rape in the first degree, rape in the second degree, or this charge called indecent liberties with forcible compulsion. Every other juvenile record can be sealed. And let me tell you, those 3 categories, there are very few. I mean, we're talking about maybe 2 a year that ever fall into those categories. Non-conviction data, diversions are non-conviction, vacated, and well, why would we have to seal diversions? I already told you that they're automatically not public and they're all automatically destroyed. It's that second diversion. If you have 2 diversions, you have to then seal them because they don't fall within the automatic destruction. Dismissals, findings of not guilty, arrests that don't lead to conviction, and a non-charge. Am I taking this right? Okay.
George is much more seasoned about this. I will stick to my PowerPoint so I don't get lost where we're at. So let's start. Who can seal their juvenile record? So what's going to happen is if you do volunteer in a clinic, or let's say you work for public defender's office, someone may come in and say, I want to have my record sealed. And so there's a couple questions that you're going to want to go through with them. And even if someone's calling you, that there's a couple of preliminary questions you can go through to discover whether or not they're going to be eligible to have their record sealed. So one of the biggest ones is whether or not they've paid off all their restitution. So we'll be going through one of the printout forms of the actual record, and you'll see there is a column on there for restitution. This is money that they owe the court. So one of the first things I always ask when someone calls is, oh, do you owe the court any money? If they're about 30, and this is something that happens when they're 14, generally their answer is, I'm not sure, but I think so. So they're like, okay, we'll look that up for you. Other people say, yes, I'm sure I paid everything off. Other people say, no, I have not paid it off. Depending on the individual, you can work with them, and then there's also sometimes legal aid organizations that will help individuals pay off their court fines so that they can seal their record. The second big prerequisite is that they have to have remained crime-free for at least 2 years. So this means that a lot of the individuals that you'll be talking to have been through the system and now they're out. A lot of times they'll be a few years out. And so you just want to make sure that there's 2 years from the time that they were released or they were before court. So let's say they were arrested on a Friday night and they were before court on Monday morning. The 2 years is going to start on that Monday morning. Now, on the printout that we'll go over, which is in your packet, there is a date there that says date of violation. Sometimes that's going to be different from that start date when they are going to, their 2 years is going to start running. So it's the time they're released from, prison, their last court date. A lot of these individuals have not served any time in the juvenile jail. So you'll need to talk to the individuals and see, were you held overnight? Were you held for a couple months? When were you released? And that's when those 2 years begin. As you can see here, and George talked about what is eligible to be sealed, you can see the Class A felony, Class B, Class C, gross misdemeanor, and a misdemeanor. And you can see kind of how everything has changed. Right now we're looking pretty good except for pre-1977, we are slowly making progress. So everything can be sealed. Class A felonies, you are going to have to wait 5 years from the time that they were released from prison or the time that they were their last time before the court. Then everything else is going to be 2 years. Again, sex offenses are going to be treated a little differently, so you're going to have a little bit more dialogue and looking more into the specific laws for sex offenses. So 2 years for most things, 5 years for Class A felony. Again, when does the time start? Sometimes this can be a little difficult, as I said, because you'll need to talk with the individual and ask them exactly if they spent any time in juvie and when they got out. So our conversation literally looks like, oh, did you serve any time in juvie? And if they say no, then we're going to use that date of violation. And if they did, then we're going to ask them how long. Generally, people have a pretty good idea of how long they spent in juvie. So let's say it was 2 months and they went before the court on January 1st. Then you're going to put those 2 months out and then start the 2 years or 5 years running from that date. Also, remember to talk to individuals who are placed on probation and modifications. George, do you want to speak real quick about that?
Sure. So if you get a local sanctioned sentence, meaning you didn't get sent away to one of the juvenile institutions, you'll be put on community supervision, which is commonly known as probation. And you'll be usually put on for 6 or 8 months or a year. And during that time, you have to report to the probation officer. You have to follow certain rules, like you can't smoke dope, you can't drink, you have to follow home rules, you have to go to attend school regularly without any behavioral unexcused absences, behavioral misconduct. And sometimes they're even more specific. And if you violate any of those, you can be brought back to court, and the court can sanction you by putting you back into their detention facility for up to 30 days. So sometimes you'll get someone who didn't go to detention initially, but then didn't get along with their probation officer or with their parents, and didn't get a new charge, but they violated their probation, they have a hearing, and then the court can sentence them back into detention for up to 30 days. Usually it's a graduated sanction, so you usually get like 2 or 5 days and then work up. But that date would count as a disqualifier. You'd have to restart the date for the 2 or 5 years from now.
So what records can be destroyed? A lot of people think that all of their juvenile records were destroyed when they turned 18. That's pretty false. And there are things that can be destroyed. So know that for the most part, most things can't be destroyed, but there are some, and those are going to be diversions. If you want, you can go to the RCW 1350-5017, and that's going to go through the criteria for the diversions. What is great is about the court forms that are being generated through the clinic is it's automatically going to print those out, and that it's a motion to destroy. So that's going to be different from a motion to seal. So that's going to pop those out, and then you'll know when you explain the individual if these records are destroyed. So let's practice. We have 20-year-old Jessica. She wants to seal an attempted robbery in the 2nd degree, and she was found guilty on June 12, 2008. So what's one of the questions that we want to ask her? Has she served any time? Good. Any other questions? Any restitution paid? Especially for robbery, that's going to be definitely one of the first ones you want to think of, because a lot of times these people will owe a few $100s or a couple $1,000 depending on how much they got out of the lift. So let's say she owes no restitution. Then what our next step is, and it's going through all the different criteria. Let's say she spent no time in juvie. Next question, have you spent 2 years out completely crime-free? If she has a theft 3 in 2009, assuming she's still a juvenile, theft 3 is 2 years requirement. Is she still eligible? Yes, we're still looking good. In June of 2010, she had a possession of marijuana charge dismissed. Are we still looking good? Yes. And if she has a citation for negligent driving dated May of 2010, and she still owes $250 for that case. Lindsay, do you want to take a stab at it?
You can't seal that case, but the prior one would be awesome.
Absolutely. Couple of things here. Number one, this is a traffic citation. We'll look at the court forms and see how to distinguish between the two. Traffic infraction is separate from criminal traffic infraction. The traffic infractions aren't going to impact their sealing eligibility. Criminal traffic infractions will. The second thing is that if someone has met the time requirement, if they owe money and they can't pay it right away, they can still seal the ones that they can pay off. So what we do, if someone has 10 charges and they're ranging anywhere from $50 to $1,000, we'll say, okay, pay the $50 one first, let's get that one sealed. After you can pay the next one, we'll get that one sealed. So we start with the lowest amount, and we just seal them progressively as they're able to pay it off.
What about the fact that her charge, attempted robbery, is a felony? Didn't she have to wait 5 years? So the distinction isn't between felony and misdemeanor. It's this distinction is between Class A felonies and everything else. Which is hard, because usually you think if it's, if a misdemeanor is 2 years, a felony ought to be worth 3 or 4 years or 5 years, but the legislature in their wisdom said no, only Class A's are 5 years. Everything else, B pluses, B's, C pluses are 2 years.
Okay, so big thing to remember, you're looking for the 5-year requirement, Class A felony. Again, there's a chart in the classification in your training manual, and you can look up the classification of each offense.
So that attempted robbery in 2nd degree, that's robbery 2 on here?
Yes.
Okay.
And what does it say in there? What?
It's a B plus.
B plus. Okay, so it's going to be Class B felony, and that will be 2 years. So we're going to go through a little bit through the juvenile record sealing process. particularly for how it's handled at the clinic that's going to be held here starting tomorrow. So we're very excited for that to get started. So first there's going to be an intake. This is like many other legal assistance places. They'll be filling out a form. And it's going to be giving us some of their preliminary information. Then there's going to be an individual who's going to be running their criminal background check. And we'll see what that is going to look like in a few moments. But this is where we're going to compile everything we can about this individual, what they've been charged with, if they owe any money. Then each group of students is going to meet with the clinic attendee, the pro se client who's coming in, and they're going to talk with them and start getting a little bit more information so we can better determine whether or not they're eligible to have their records sealed. They'll then log onto a website and complete all the necessary forms. Again, you're going to print those forms and go through and have the pro se client sign a bunch of places. If they have more than one cause number, give them a break in between signing everything because it's a lot of signatures. I tell them they can feel famous for about 10 minutes because you need their autograph over and over and over. Something really important, make sure you do not miss any pages that need to be signed because this can be detrimental when they go to get their order signed and make it so they have to restart the whole process. Yes.
You use the cause number of the criminal proceeding?
Yes, and we'll go through an actual printout example of it, and so we'll show you the exact line to use on it.
And would that include the police department and these other social files?
Yes, what we'll do is that's a great question though, because all these places have their files. That one cause number is what connects that charge to all the different agencies. So once we put in that cause number in the correct police department, that information will get sent to the police department, and the police department will be able to look it up through that cause number. It's a great question though. After you get the pro se client signatures, you're then going to make copies so that they have the forms. Again, this is a pro se clinic, so these individuals need to understand they're representing themselves. They need to keep copies of everything, and they need to be taking notes that they feel are important so that they can keep it in their own file. There is then an individual with the clinic here, Alyssa, who will be going through and doing a lot of the back end, a lot of the filing, and she's going to be setting the hearing date, filing the motion, serving all the necessary parties, and we'll get a little bit more into that. The reason we want you to know is you're going to be explaining to this to the pro se clients so they can know what's happening with all their paperwork. Any questions so far? Okay, this is an easy one. Clinic starting tomorrow, and it's at 10 o'clock. And I believe Lindsay's the person to talk to if you want to get more involved in actually volunteering.
For volunteer coordination, Laura, raise her hand.
Laura? Laura? Laura's the one to go to if you want to start volunteering.
Is it right here in this room?
Yeah, this is where we're going to do all the intake, and then we have other rooms for the individual meetings. So again, what happens at the clinic, we have an intake, criminal background check. You're going to pair up with another volunteer, wait for your assignment so that you know which pro se client you're going to be speaking with, interview the participant, talk to them, fill out the forms, and then you'll be able to explain to them the follow-up from the clinic. So let's start with intake. Concerning intake, a lot of individuals who come in are not going to remember specifically what happened, or what happened relating to the offense. A lot of these people, this happened over 10 years ago, and they literally completely forgot about it until all of a sudden it started popping back up and they got fired from a job, they got denied a promotion, or they got denied housing. So a lot of times individuals will not remember exactly what the information is, but your job is to get the best available information. So talking to them, really asking probing questions about if they served any time in juvie, how long that was. If you need to, getting more accurate information, saying, hey, here's our information. Go home, see if you have this paper, email us back, and we'll work from there. Another thing is that in Washington State, there are moves to change the record sealing laws. So something we've been doing a lot is asking the pro se clients questions about how it's impacted their future or impacted their past, whether it's stopped them from getting jobs, housing, scholarships. We have a lot of nursing students come in who they got denied internship opportunities because of their record. So really gathering all these stories, and depending on how the clinic wants to work, you can potentially use those for more legislative efforts in the future. So this is, gotta keep up with myself here. This is what the intake form is gonna look like. As you can see, the space to write is kind of short, and not all of us have great handwriting. So one thing I think that's really important is because you're gonna be keeping a paper copy is making sure everything's legible, and if it's not, don't be scared to write under it the actual phone number, the actual address, and all of that. Don't be shy about it. If you can't read it, you need to ask because this information needs to be accurate. So just write on the side with the actual addresses if you can't read it, and have grace on them because it's really hard to write it in the small spaces.
If they're pro se clients and we're not representing them, why do we need their addresses and contact information?
So part of the reason we keep their information is because we're going to be notifying them of their actual court date, and also we're going to be inputting that information in the court forms that we're helping them produce. So this is just one way to keep track of them, and most importantly is the investigator who's looking up their background checks, they're using this intake form to pull up that record. So they're using the date, birth, any aliases, that's a really big one. If you've been involved with the law a little bit, you may be tempted to have a couple different names you go by. So alias is really big. And then for the phone, address, and email, it is so we can get in contact with them if anything comes up. So the investigator here at the clinic is going to run a criminal background check, and they're going to go through JIS, SCOMIS, and these are really the most comprehensive searches. There's one more that will get done on the national level, but this is for state level criminal background checks, so they'll be pulling those up. After that, a volunteer attorney is going to review the criminal background and make sure that all the 2- and 5-year requirements, restitution, everything is good to go before they send you off to go meet with your pro se client so that no one's getting their time wasted. After that, you'll have the case referred to you and your student or your volunteer who's helping you. And then after that, you can meet your pro se client. And with that, I will I'm going to go over this real quick before I pass it off to George. This is what makes our clinic work so well, is that you have access to their criminal backgrounds. A lot of people don't know that they have a criminal background until something happens to make it pop up. So it's probably pretty hard for you to read it. So if you go to page 15 and page 16 of your volunteer packet, you're going to get something similar to this. And going to your question about cause number, does everyone have it on page 15 and 16? It has a lot of little boxes on it, but underneath all the little labels is going to be the actual background. So it should look like this. Down there, great. So this is that without all the art on top of it. So up top, there'll be their name, and again, their aliases. So sometimes the investigator is going to have to run 5 or 6 names if they have different aliases. That's why it's really important that the individual has filled out the intake form correctly, and when you go through the interview, you'll be asking them, oh, are there any alias names that you go by that you forgot to put down, because we want to make sure we're covering our bases. Up in LEA, if you go down, it's going to be the law enforcement agency. And these are from Seattle area, so you'll see RPD, Renton PD. But if you go to page 19, that's where you can decode what those 3 letters mean. So a lot of yours will probably be the Spokane Police Department. But just in case you have other codes there, you're going to want to be able to look those up real quickly so you can put in the correct place. Next, if you go to TY, that's the case type. If you go to page 17, on the left-hand side, second paragraph down, it's going to say case type, and it's going to explain to you what all these little codes mean. So an IT is a traffic infraction. CN is going to be the criminal non-traffic. And as we talked about before, the CT is a criminal traffic. So we know a traffic infraction is not going to impact that time running. However, criminal traffic is going to. So I'm just going to keep going. through, the next thing you'll see is the actual offense. And this is where you're going to go to your classification of offenses. And that starts on page 8. And you're going to figure out, so this person has a, say, marijuana possession. So you'll go through your classification of offenses. You go under drugs on page 9. You'll see it there. And that's how you're going to determine whether this is a Class A, Class B, Class C, gross misdemeanor, or an actual misdemeanor. So that way you know how much the time needs to start running. Next, you're going to see to the right the restitution owing. And this is the money the individuals owe to the court. So here we can see this individual owes anywhere from $173 all the way up to $562. If this person had $200 in the bank and they wanted to seal one of them, we would say, hey, go pay the $173 one. Let's get that sealed. After you can pay the $213 one, come back and we'll get that one sealed as well. So you can just go down the list for whichever one's more expensive. If you go to page 16, this is going to answer your question about cause number. So for the criminal trespass in the second degree, you can see it's 088000909. That's the cause number. That second 8, the one in between the dashes, that's going to tell you that this is a juvenile offense. So all the juvenile offenses that are going to be eligible, they're going to have that 8 on them. If you go to the right, do you have questions?
If you have things that want restitution, are they additional that constitute the process?
No, we can generally say yes.
That was what
All your legal financial obligations will show up.
So,
does that have to be paid as well?
Okay. We're going to say,
Sorry.
we're going to say yes.
what was the question? So Rosie's question was, there's often a VPA, victim penalty assessment, of $90. So how much is it? Or $100. That's tacked on to however much money you owe, and it's tacked on to every single charge. That money still has to be paid. So that's included within the restitution. Any other questions so far? We're kind of going through this quickly. Okay. The next to your right, you're going to see the date of violation. Again, we're on page 16. And this will generally be your starting point to see if they meet the time requirement. So asking them, so he was charged October 19, 2007 of criminal trespass, asking, did you spend any time in juvie? If so, how much time did you spend? Putting that date out and then starting the 2-year clock. However, on this one, you'll see that he was later charged in 2008, still as a juvenile. So the 2 years would start after the last conviction. To the right, you'll see judgment type. And again, you can go to page 17, this time the right column, and you can go through and see, okay, G is for guilty, DP is for deferred prosecution. You can go through and kind of decode this. And then our last one on the right is case disposition. And you can turn to the next page. You can see whether it was completed, closed, transferred. So this is my Bible for when I am trying to decode a criminal background. It will walk you through. It doesn't have absolutely everything on it, but it has a lot of the really pertinent information. So what I do is when I'm volunteering, even if an attorney goes through it with me and I'm like, oh great, they're eligible to seal, I still take this back before I make a fool of myself in front of the pro se client, go through everything, double check it, until I'm really familiar with their criminal background so that if they have any questions, I don't have to flip through this in front of them. I can say, oh, this is this, because I've already checked through it. So there's just a little hint for that. And then George will pick up for meeting and interviewing the client, or pro se clients.
So I think Angie gave me a good segue to come in when she said don't want to look foolish in front of your pro se clients, so you should try to understand what you do. Now, I know a number of you are attorneys. How many are law students? And how many have taken any type of interview course, client interview, clinical program? Anyone in the clinic programs? So in the clinics, do you do client interview training? So how many have done that? So, okay. I don't want to do this all over again. It's something that everybody had. One of the, I think it's Seattle University now, before you can do any type of clinical program, you have to take what was the name of that course? Some type of course where you do the training. But let's talk about the interview. So, whoops, got to do that. So first of all, they're not clients, but they are looking towards you for information, so you want to look as if you are the person that can give, you can confidently, someone can look at you and confidently think the information they're getting is accurate. So you don't want to go to the clinic wearing cutoffs, jeans, tank tops. You want to look somewhat professional. You don't have to come in a coat and tie. You don't have to wear this lovely suit like Angie's wearing, but you've got to look so that the information that you're conveying will be taken in some degree of confidence that your information is accurate. Okay, so how do we start our interview? We've already told you that you're going to get criminal history, you're going to get an intake sheet, you're going to get an opportunity to talk with a volunteer attorney before you meet your client. You'll be working, we believe, in groups of 2, maybe 3 volunteers, and you're going to then meet your client. And what do you have to convey to your client as soon as you meet them? Okay? Who you are. I am not a lawyer. You don't have to say that. You say confidently, I am a law student here at Gonzaga, and we are going to help prepare the paperwork to seal your juvenile records. I think that's a pretty good way to start it off. There may be some, if you want to talk about the Seahawks catch on last Sunday and say, wasn't that an outrage? And, it's something to break the ice. But so you want to do some type of rapport building. How are you today? What did you think about let's see, the WSU game wouldn't have happened, The UW game, right? What did you think of the UW game? You want to go over the intake form with your client, and we had that up on the air, because you want to make sure all that information is accurate, so that we do actually have Rosie Thurman's report and it's not somebody else's. We want to know your address and contact information, and as I said, the reason we need that is when when the pro se client leaves the clinic, they will not know when their court date is set, because that's something we have to get after we filled out the paperwork. Alyssa will have to go to the courthouse, get that date from a court clerk, put that on, send out notice to the various agencies, and one of the people that will get notice will be the pro se client. So we need to have accurate information so they'll know when to show up next. And more importantly, they'll have an idea of how long it's going to take to get this record sealed. We also talked about how this has affected you for the idea if we need to do some type of legislative work. And we want to give a roadmap. What's going to happen next? So we need to know, you need to know something about the juvenile process, or the sealing process, not the juvenile court process. We have to know that there's notice that's going to be sent out. The agencies that receive the notice have to have a reasonable opportunity now to respond and say, oh no, that record shouldn't be sealed. I don't think I've seen that ever in the 8 years I've been doing this, but it could happen. So I talked with the prosecutor here in Spokane, and the prosecutor said he thinks a reasonable time for notice is 2 to 3 weeks. So Alyssa will go to court, get a court date somewhere between 2 and 3 weeks from the time we send out the notice. If no one responds, which I'd say we usually never do, then the next step would be for the prosecutor to review and make sure there's no restitution owing, that there are no out-of-state convictions, and then he will sign the form and take it to the judge, and then there'll be a court hearing. Now, we don't know whether the judges are going to require presence of the pro se clients in Spokane County. We don't know that yet, but we'll find out. But for the first clinic, we will tell our clients that they have to show up at that court date. Now, let's talk about the interview. So you've introduced yourself. You've told them that you're a law student. They're here at Gonzaga. So you communicate your role up front and the process. We've gone over what the process are, who you are, what you're going to do, that you're not their attorney. They are not clients of Gonzaga University. They're not clients of Teen Child. They are doing this pro se. I think the term is now, what, unbundled legal services? I think that's the new euphemism for this. Unbundled legal services. Why are you here? Now this may, I mean, it's obvious why they're there because they have criminal history, but sometimes there's a pressing need. So we get a lot of kids, they're not kids. People who are coming to you, let me tell you, are not kids. The only time we get like someone who's 19 or 18 coming is when their parents are dragging them in by the ear and saying, get this sealed, get this cleared up. Most of the people are coming there in their 20s. And why are they coming? Because they've just been denied Section 8 housing. They've just been denied, their landlord wouldn't release them their apartments. They've applied for a job and their boss says, okay, I see you've got this criminal history, but I like your work ethic, get this sealed and then come back and we'll give you the job. So there's some type of immediate need most of the time. It's not just, oh, it's in the wind and I can get my record sealed, I think I'll stop in. There's usually an immediate need and we want to know that. So we know that if we seal this theft 3 or this theft 4, but he still can't pay off the debt that he owes for taking that motor vehicle, but his employer only wants that theft charge off, or the Marine recruiter only wants that assault charge removed. We want to know that so we can figure out what we have to do and strategically do it. What power do you have and why and don't you have? So you're not an attorney, you're not the one who seals the record. All you're doing is helping prepare that, and a judge decides whether or not the record can be sealed. Touch that one. What is expected of the pro se client? So we expect that the pro se client will appear and be responsive. Sometimes we have to get more information. The prosecutor gets this form and says, could this be the same John Smith that I see was convicted in Missoula, Montana 10 years ago? So you want to be able to get to your client and find out if there is some reason why he would have been in Missoula. And they're expected to show up. Be yourself, adjust the way you talk, but don't adapt to an alter ego. I mean, these are just basic interviewing skills. You don't want to talk down to the client. You want to be interested. You want to appear to be helpful. I used to supervise juvenile attorneys in Seattle, and every year I get a couple of law students from the UW or Seattle U, and they come and they think, well, the only way that I'm going to build rapport with my client is to show that I'm just like them, and it backfires every time. Okay, you don't want to identify with your client. You want to build rapport, you want to build trust, but you don't really want to reveal personal information about yourself that will make you appear to your client to be more hip or cool. You don't need to do that. Because they're not there to make friends. They're there to get a specific task done. And the more businesslike you can appear, but still be friendly, the better off you are. What makes you comfortable usually makes your client comfortable. Gauge the language level. You know, even this is more for when you're dealing with juvenile clients, but I find a lot of my clients, pro se clients that come to the clinic, still have the same literacy level, low literacy level, or those learning disabilities that they had as a juvenile still carry through into their early 20s. So you want to be concrete, you want to be able to explain something and maybe explain it in 2 or 3 different ways so that your pro se client will understand. Above all, you want to be accurate. You don't want to make any promises that you can't hold. This may require a little practice, and we'll try to do that in a few minutes. We'll try to do a little role play. These are just some questions that you can ask. What law enforcement agency arrested you? That'd be really helpful. Now, they may not know the specific law enforcement agency, but they'll know whether they were within the city of Spokane or just in the county of Spokane, or if they were within the city. Sorry, I don't know any other cities here in the county, but that have police departments. Were you convicted? Are you on probation? Are you on probation for anything, not just the old juvenile matter? If you're currently on probation, does that bar you from sealing your juvenile record? Yeah, right? You cannot have any criminal charge pending, adult or juvenile. Even though if you've waited 15 years as a juvenile, you should be able to, but because you picked up that DUI, you're not going to be able to seal your juvenile record until you finish that. Have you paid your restitution? These are all things that you need to know. You spend time. Check for understanding, getting information. As I say, rephrase, repeat, and you're going to see I do it even in this PowerPoint. I'm going to have one slide. You're going to see it. It appears 3 different times because I think it's important that you know this process and that you'll be able to communicate it to your clients. So your pro se clients. So I put this slide in 3 different times, and he's telling me, we're flying over here, she's saying, this is a repeat of the slide before. I said, well, we'll see why. So you have to rephrase, repeat, and ask questions to clarify, to make sure that they understand whether or not they have to come back to court. Giving information. I don't know how many, well, the attorneys all know, but most of you haven't been to, anyone been to court, like municipal court, watch any criminal proceedings? Yeah, well, that'd be attorney. Okay. In the guilty plea forum, the guilty plea colloquy, the judge asks a series of questions. And what responses do they get?
Yes.
Do you understand you have a right to remain silent? Do you understand you have a right to confront witnesses? Do you have a right to have an appeal? What do you get? Yes, yes, yes. Do they understand any of this? Do people understand what it means to have the right against, the privilege against self-incrimination? Not many. And they're not going to understand a lot of this process. So it's simply having them nod is not going to be enough. You're going to have to make sure they understand. So these are good questions. So when I see you again, what are you going to bring with you? This would be for the person who didn't pay their restitution and we need that little receipt from the court. What will happen after the court date? Because you'll explain to them. They'll be given a copy of a certified copy of an order sealing their record. And they're free to make as many copies as they want of that, and they can pass that out to their employer, their landlord, their parents, whoever they need. But you want to ask the question in that frame rather than saying that, well, after the next court hearing, you'll get a copy of your certified copy of your order, and then you can do this, this, and this. Say that, and then ask them what can happen. Keeping control of the interview. A lot of clients really like to talk, and it's they're focused on some small detail of their offense, and you're there getting more of a global picture because you've got to figure out whether they're eligible. So if they have a thing that's not really relevant, you want to acknowledge it. Well, yeah, that's a good issue, but then move on. But I've got to get this information from them. Too much information, you want to try to redirect your client, your pro se client, to be focused on what it is they're doing here. Phrasing questions that ask for more things at one time. And don't make promises that you can't keep. Okay, I really need to get this record sealed. My boss says I can get this job tomorrow if I can get this sealed. Okay? You can't promise that you can get it sealed tomorrow. You can't promise it'll be sealed in 2 weeks. You can't promise that it'll be sealed in a month. You can't even promise it'll be sealed. I think if you took that RPC course, there's a great case, the Cloud case, where some attorney makes a promise to his client awaiting trial on an assault charge that I can guarantee, almost guarantee you that you will not be found guilty if we go to trial on this guy. Had a great offer of probation, but the attorney convinced him. Okay, that was found to be a violation of the rules of professional conduct. Don't make a promise you can't keep. And here's the big one. Yeah, I was arrested, but I didn't do it. I didn't do it. I wasn't guilty. My attorney pled me down, and they said it was a good deal, so I just pled guilty. I never hit her. I never stole that car. I was riding in the car. I didn't know it was stolen. Okay, those are all great issues, but you've got to be able to acknowledge that, and move on, because it doesn't matter what the defense was, what wasn't done, what was done, how good or bad a job you think your attorney did. It's irrelevant. We're here simply to seal the record. We're not here to appeal it. We're not here to grant a pardon. We're not here to excuse it. We're just here to seal it. And this is something that comes up all the time because people are embarrassed. Oh, I see in your record you have a charge of taking a motor vehicle. Yeah, I did, but when my brother took it and I was just riding along, it doesn't matter. We're just sealing the record. And that's the hardest thing you'll run into when you talk with your pro se clients. They're embarrassed, and you don't want to further embarrass them, so you want to acknowledge that, but then redirect them to the reason they're here. Yes, sir?
Now, are they going to be one-on-one, or are they going to bring their parents tag along?
We do it. We ask them. When they come to the clinic, if they come with their parents, we ask if they want the parents to be there or not.
Because that sometimes interferes with getting the truth.
No, because we're not there to get truth. It's not like an interview where we're trying to determine whether or not the crime was committed, a regular interview in a criminal matter. We're not here to get the truth.
Well, what about his or her criminal record? Do you tell the parents all about it?
Only if, these are adults. These aren't kids. We don't have to worry about the,
Okay.
So these
Let's
are
talk
adults.
about third parties.
Yeah.
Okay.
If the pro se client wants their parents there, or their boyfriend there, or their girlfriend, sure, we have no problem having them come. But if they say no, then we simply say, well, we're just going to talk to John or to Mary. Now, sometimes the parents are there and they really want, but that's so rare that you're there, because most people who come to see us have an immediate need. They just need this part of their record cleared so they can join the Marines and go off. Or that they can get this and they can get that job down at Wendy's. It's not, it's very rare that, well, there will be a lot of young couples who will come in with kids, and if you're going to have kids in the room, and it might be helpful to have some toy available. But that's only because they weren't able to get daycare because they didn't have a job, they couldn't pay money. So again, it's an immediate need. We're not representing kids. No one you'll see is going to be under 18. No one. So you don't have to worry about having parents' permission to do anything. It's whatever the pro se client wants to do. Okay, as I say, it just doesn't matter. Okay, here's the first of my 3 slides. What happens at the clinic? I think this is the second of the 3 slides, because Andy's already gone over this once. We do the intake. We look at the criminal, we give that intake sheet to an attorney or investigator who will run the criminal history. We get that, we do a check, we pair up, or let's see if we decide what we're going to do. We're going to pair up, triple up, whatever. Somewhat we're going to do that.
Catherine's call.
Catherine will-
It'll depend on how many students we have.
Okay. No more than 3. Never works with more than 3. You wait for the assignment. When you get the assignment, you'll get the criminal history, you'll get the intake sheet, you'll talk it over with a volunteer attorney, and it will already be screened for minimal eligibility. The attorney will be screening it, looking for the number of year, have we met the 2-year or 5-year? Is there any restitution owed? And if there is, the volunteer attorney will talk to the client and explain to them why we can't proceed today. So for the most part, by the time they get to the student volunteers, they will have been initially screened as far as eligibility. Now, things may come out during the interview that will raise questions, but for the most part, you'll be able to just start your interviewing the participant and filling out the forms. And that's where we're going to go to Angie, and this is the crux of the matter, and it's how you fill out the forms. And after years of struggling with this, we think we have a fairly good automated system. And Angie's going to explain how we do it.
All right, so we've been here an hour and 25 minutes, so if you have your computer, you're going to want to make it so you can easily get to a website, suppose Facebook, Gmail, whatever. And we're going to move to how do we actually complete these forms. So again, using your volunteer instruction packet, like your Bible, if you open it up to page number 1, titled Pro Se Client Interviews for Law Students, you can see we've kind of already gone through preparation, introduction, explanation, and then number 4 says conduct screening. So then if you go to page 5 and 6, and all the way through page 7 is going to talk about the screening. This is when you go through cause numbers, you figure out if they're eligible to be sealed. Literally, if you ever have a question, I would read through this entire thing, and definitely before you volunteer at the clinic or plan on taking a client as your own, maybe as a practicing attorney, read through this entire thing because most of the information that you'll need is on there. So after you've gone through the screening procedures, you're going to go back to page 1 and go to form. Number 1 is going to say go to the website. Something important is you're going to need to use Internet Explorer. So I don't know about you, but I always use Google Chrome, so it took me about 20 minutes to figure out Google Chrome will not open this website as I want it to. So open up Internet Explorer. Does anyone not have Internet Explorer on their computer?
Yeah, but you have to have 6.0, so basically people with Macs can't do it.
Is there Internet Explorer for Mac?
No, I searched for a really long time. Yeah, they used to have one, but it was a version before the version we have used, and now it's not allowed anymore. So I searched around and I can figure it out.
Okay. So if anyone's a tech guru and can help us out later, otherwise what we'll do in the clinic is make sure someone has a PC that's paired up, because only one person really needs to be able to access this. So on a PC, you're going to go to the website. And this is one of the short links. You can also get to this website a couple different ways, which I'll show you. This will probably be the easiest way. So you're then going to scroll down to sealing juvenile court records in Washington. And then what is really nice about this website is that because these individuals are pro se, they need to be able to access their paperwork. They need to understand that they are doing this, we're just assisting them with it. So what we'll have them do is sign up to save their work. So you'll literally have them go through this process. There'll be a self-helper. I'm just going to make up an account so you guys can see how easy it is. This is my fake name I give to people who want to spam me.
Is that email address mandatory?
It is mandatory.
Why not, if they don't have one?
If they don't have an email address and you have a couple minutes, I would suggest just setting them up on a Gmail account. You could also use your own email account, but I think it's really important that these individuals take complete ownership in what they're doing. I set up a different Gmail account in about 2 minutes the other day, so that's probably going to be your best bet.
But you could use your own as a placeholder.
Mm-hmm. So then sign up now. And now we can continue. At this time, I would then take the computer back so that you're in charge of going through everything. You're going to click Start Fresh. This will show up on Internet Explorer. Most of you, if you're trying to do this on a Mac right now, it probably won't work. If it is working though, let me know. So if anyone wants to try this on all their different internet programs, feel free to do this. So this is going to have a lot of the information that we went over in screening procedures. The cause number, was it dismissed, guilty, do you owe any money? So you can just always click yes, because you have the information, you've already gone through it. And then you're going to click next. You're then going to put in their information again. This you can get directly off the intake form, but if you have any spelling questions, you can kind of go through it with them. So I'm going to be a fake person, Angela Trevino. Put in their birth date. And I'm going through this with you so that when you go and sit down with someone, it's not foreign. It's something you're used to. You're like, oh, I know. It will be fine. What's the zip code here?
19202.
So you put in all that information, then you can hit next. Let's say I have a misdemeanor theft. That was guilty, so I'll put in guilty. I was convicted in January 2000. Something really important, you then need to click calculate eligibility. Otherwise, the program is going to kick you out. So you click to calculate eligibility, and the program is set up so that if 2 years hasn't passed, and it will refer you to a bunch of different agencies. So that's what's really nice about this website, is it does a lot of the screening for you.
So are they filling this out?
You're filling it out, and you're doing it based on the criminal background check that you have, but you're filling in all this information. But technically, they could go home, and that's the point of this, is you can technically go home, and they could do this themselves. But a lot of people don't have their criminal background, and it seems extremely difficult for them to go through to the court and get all this information and understand everything. So that's why it's a service that we feel it's really important to offer. Are there any pending criminal proceedings against you? Have you paid all the money owed to the court? Oops, video. Then you click next. What offense? So you're going to put in the offense. Something on the criminal background, sometimes it's going to say robbery/assault. You're just going to put both of those in. So let's say they're both in there. I don't think you'll ever see those together, but I can spell, I'm a law student. So you would just put it like that, assault/robbery. What county? These are all going to be Spokane County, which is S17. What law enforcement agency? Sir, I believe you were getting at that. A lot of times this is going to be the Spokane Police Department. But if it's another one, we'll see what to do here. Right below, is there another law enforcement agency involved in your case? Let's say the Spokane County Sheriff was involved. You can just put yes, and then put in that information as well. These are all going to be Spokane County, and then cause number. Again, the 8 is important because that again is signaling to you that it's a juvenile offense. And then you can click next. This is what you should see. It's a dialog box that's opening up. Click OK. Yes.
Oh, I'm just curious about, I guess, other states. Do we have any, if they have some infractions on their record from states other than Washington? Are we able to do anything, or only Washington State?
The clinic is set up only for Washington State juvenile records. You can do personal research on it. A lot of states automatically will seal their records when they turn 18. So you can just do a little research, look it up, but ultimately you'd probably be referring them to another attorney in another state. So you'd want to work with your attorneys at the clinic to kind of see what course of action to take from there. So here's the screen when you're all finished, and you can click Get Your Document. And congratulations, you just completed the court forms for it.
So what do you get back for completing the forms? What's produced?
So what is produced when you produce or when you hit Get Document is the notice, motion, and declaration, and then the order. So this first one is going to be the motion. Let's see where the notice is. This is the notice, up top is the motion, and then the order as well. So, what are all these court forms? The notice is giving notice to all the different agencies that you're going to be serving. So you can see on here, it's the clerk's office, juvenile division, court administrator, Spokane Police Department, Spokane County Sheriff, Washington State Patrol, JRA, the Spokane County Juvenile Records. All these places have a juvenile record. So that means a copy of this notice to seal, as well as the actual motion and declaration to seal, is going to get sent to all of those agencies. So what Alyssa's going to do is when she goes to court, she's going to set the court dates. She's going to make this many copies and send a copy of that to all the different agencies. That's the notice in motion. And the notice is telling all these different agencies, we are filing a motion with the court to seal this individual's records. If you want to object, come to this court date. We've never had that happen before, but this is how you have to proceed if you want to have your juvenile records sealed. And then the actual motion is what the court cares about, and that's the actual motion to the court to seal the records. So here was the notice, and again, up here's the motion. Now, when you have all these forms, you're going to print them out, and this is the time you're going to go through and get all the autographs from the individual. So as you can see, right here, we're going to have date and sign, make sure their address and phone number is correct. They don't fill this out. This is what's going to get filled out at the court, but they're going to date and sign right here. And then they're going to sign right here. The date's going to sign and put the date, excuse me, the judge is going to sign and put the date here. So there's a lot of signatures. It's also going to produce the information as if this person wasn't coming through the clinic. So all the filing instructions that Alyssa's going to take care of on the back end of the clinic. But it's really nice for them to see this because they need to know what's going on with all their paperwork. So I think it's really important that they can go through and say, oh yeah, all this happened. One other thing is if someone has multiple cause numbers, what you're going to do is you're going to get the document and then you're going to go back to questions. It's going to look like you have to do everything again, but you don't. You can just click next through, and then you're going to put in the next offense. So let's say I was found guilty of a Class B felony in 2001. I'm going to go back through this, calculate eligibility, go through. Just say it's a simple assault. You're going to put in the new cause number. So you're going to go back all the way through it and make sure that everything is correct. And then again, you'll be able to click next and generate those next court forms. Is there any questions about that? It's kind of a backward way to do it. Yes?
This is just Spokane County.
You can do this in any county in Washington State, and individuals actually will be accessing this website from all over Washington State.
However, for our clinic, we're only doing the Spokane County ones because since Alyssa's going to have to go through all the paperwork, we're only working in the Spokane court system. So while they can do it for other counties and it's possible with other counties, for our clinic, we're just Spokane County.
That sound good?
So people that are located in other counties but have a juvenile court record in Spokane County are welcome at your clinic?
Yes.
How do you contact them?
How have we been
about the
advertising
clinic?
or?
Yeah, how do you invite them to come?
Well, we've been advertising in various different ways. So, I mean, that is a matter of how do we contact the people who need it. Do you have any ideas for us? Michelle's the one who's been doing a ton of advertising with various local agencies, housing agencies, different, I know she's done some advertising with the court systems and a lot of parole officers, public defenders, but she's also contacted local charities that, people, when they get housing, when they run into those roadblocks, the agencies that are helping people with those roadblocks.
Oh, not at all. And this is, sorry. Her question was, if people come in with convictions from other counties, what do? Send them to this website. And also, I'm going to show you another website. It's the Team Child one. It's actually also in your instruction packet. That is a statewide database for everything to do with juvenile record sealing. So on there, there's actually a chart that breaks down how every county processes requests to seal juvenile records. Most of them are pretty similar to Spokane County, and they're going to use these court forms. However, some counties do it a little differently. So if that happens, just tell the individual, call this specific court, ask how they process it. They say they want the standard court forms, go back to this website, and then proceed. And they'll already know how to because you walked them through it. That's a really good question. Any other questions? I want to show one other glitch. We're still working with this computer program. I think it just got up and running in April of this year. Is let's say the individual was found not guilty, but it's still showing up in a criminal background. For right now, you're still going to have to put that they're guilty. And then, so it's for not guilty, non-charged, dismissed, and vacated. For all of those, you're still going to have to put guilty, produce the court forms, and then if you do a quick search on guilty after doing that, this is how I figured this out, you'll find out there's only one actual place that it says found guilty. So you'll go in there and literally just type it in, not guilty, after it's enabled. Make sure you enable editing, but then you can just put that in so that it's accurate. Are there any questions about that? That's another back way. Yes?
How is that different from doing the deletion or expungement of the non-conviction data on the Washington State Patrol website?
The destruction forms?
Yes.
The destruction forms are going to be for diversions.
And dismiss cases?
So she's talking about the material that's housed at the Washington State Patrol on arrests and non-conviction data. And under 10-101, 10-72, I think, you can ask to have that destroyed. And that will destroy that, but it doesn't take it off the court records.
Okay.
So even though it's been removed from Washington State Patrol records, it's still available, and this shouldn't happen because all criminal records are supposed to be at the Washington State Patrol by statute, but yet the court has now felt they have a mandate to publish all court records, which includes criminal history on theirs, and they don't respond to the Washington State Patrol requests.
Okay, that's really good.
And it's really, really confusing.
I couldn't hear part of what she said. Could you just repeat
Sure.
that real quickly?
So in our state, all criminal records are housed at the Washington State Patrol, and there's a specific RCW 1065 or something that says that you can request that the Washington State Patrol remove your records after a certain period, or for mostly it's for non-conviction data, dismissals, not guilty. And that used to be all there was. Then the Washington Supreme Court decided that all court records should be made public. And so they duplicate all the information that's at the Washington State Patrol, and they don't respond to the request to seal it when you get it removed from the Washington State Patrol. So that's why we have to seal this. By us giving notice to the Washington State Patrol, they will follow the court order and will seal the records. So you have to do this in order to take care of it. And for several years, no one really could understand that. So, but it's a great question. It's something the legislature's got to come to resolve, because they mandated that all criminal history and all criminal records would be at the Washington State Patrol, but yet now the courts are duplicating that. And the courts and the legislature are two different bodies.
Any other questions about this?
Let's say that this person wants to get clearance for housing, and they've got their record sealed. Now, do they automatically get their credit report corrected, or do they have to go through that, send 3 letters to the major agencies with return receipt requests and asking that they clear their credit?
I'll get to that, but that's a really good question because it's not as simple as with a lot of legal things. It's not as simple and straightforward as it should be. So I'll get to that in a couple of slides.
Okay.
And we'll make sure. And then after that, if there's any confusion, let's visit that again. So we just completed the notice, motion, and declaration. Again, if you had put a diversion in there and it was eligible to be sealed, the notice and motion to destroy records will pop out. The really important part is that you are reviewing this with the pro se client. This is so important because they're signing everything, and as boring as it is, they need to understand exactly what they're signing. So go through the entire document with them. Give them a little space. If they need to get 5-10 minutes, say, hey, take 5-10 minutes and read this before you sign it. You really want them to understand that they're signing their name to this, so they need to certify that all that information is true and accurate. And make sure everything's signed. Again, everything but the first page of the order should have a signature on it. So if you ever have someone come in with about 10 cause numbers, you can figure out real quickly how it's easy to get sloppy with this. But it's really, really important that if you need to, you go through it once and then have your partner go through it once. And then depending on the administration of the clinic, for us, we generally have at least one, myself or another attorney going through it just to make sure all the signatures are there because it's really important. So make sure you're taking the time, no matter how boring it is, to go through and double, triple check all the signatures. The process, again, as I explained before, is that we're giving a notice to all these agencies and parties of the hearing. We're also giving them the motion to the court. We give them notice and motion all together to all the agencies so that they know what we're giving them notice of, the actual court form. Then the declaration is saying this is what we are asking the court to do. And then the individual will have, they won't have to attend it in most cases, but, is that correct? Is it, okay, for the actual hearing, oftentimes the prosecutor will just, or the judge will just sign it. I believe it's important that they're there. That's how we do in King County. They have to be there, but a lot of times the judge won't want to talk to them. But they still need to be there. This is their court hearing. They're pro se, so they need to be at that hearing. And they will get notice of the time and date of the hearing from the clinic. I realize I just said two contradicting things. Go with the second thing. They need to be at the hearing. Any questions? Yes.
No formal hearing for all of them? Is there always a hearing?
There has to be that hearing for that judge to sign it. How that goes about is very different from judge to judge. And I can only speak from King County, and still from King County, depending on the judge, it goes differently, and depending on their calendar for that day, it will go differently.
Angela, is it a discretionary decision? Do they have discretion?
In most cases, no. They have to seal it by law, but there's a lot of little things that you can do to stop a sealing order from going through, even if it's just delaying it. I don't know if you want to speak more to that.
Prosecutor in Spokane believes that it is ministerial. Once you reach the criteria, it must be signed. That's not to say a judge will sign it, but the position is if you meet the criteria, it has to be signed. But we've seen judges not sign it.
It's a good question, though. Any other questions? Okay, seeing none, we'll move on. Again, going through the process, we gave notice, and we always schedule the court dates at least 2 weeks out from the original notice in motion. This is giving all the agencies a chance to put it on their calendar and attend the court date and contest the hearing if they want to. And the hearing has to be held in the county where the charge was filed. So a lot of people in Washington State will move around, and the hearing needs to be in that county where that original charge was filed. So if they were in Spokane and then they moved to Tri-Cities, they would technically need to come back to Spokane to attend that hearing. But again, if you come across those kind of circumstances, definitely talk to the attorney and the individuals at the clinic and see what can be worked out. Okay, we're getting to the end, I promise. Almost been here 2 hours. So what happens next? This is really important that you explain to the individuals that are coming in. As I've said multiple times, they are pro se. They need to understand what the process is, that all their paperwork is going through. So let them know we'll set a hearing date and file a motion. And then I always show them that list and say, hey, just so you know, I'm sending this paperwork to all these people. And they're usually like, oh my goodness. because it is a lot of individuals, and a lot of times they don't understand how many different agencies have their records. Let them know the hearing date will be about 3 to 4 weeks out. They will be notified of the hearing date and time as well as the courtroom, and that they do need to appear at the court. The judge should sign that order that day unless anything pops up, and they should be leaving with a certified copy of that sealing order. Again, on the clinic end of it, Alyssa will be making copies of that signed order and resending it to all of those agencies, telling those agencies they need to sign the order. The motion may still be denied, and these are some reasons why. If they find an out-of-state conviction that we didn't pull up, sometimes they find that our dates are wrong, especially if we're guesstimating, because people don't remember exactly how long they were incarcerated. If they still owe money, and sometimes people are in pending matters, which would disqualify them, so they need to wait till those pending matters are resolved and then start that 2 years or find out that they're eligible to have it sealed. And again, if the prosecutor, oftentimes, if they say that the individual is not eligible to have their record sealed, they will oftentimes be told prior to the hearing that they're not eligible so that they don't have to waste their time going to the court. You can't guarantee it though, so I'd let them know, hey, you may be contacted earlier than the court date, letting you know you don't actually need to come because we have to resolve another issue before you're eligible. I'm going to review this a little bit, and then George is going to go into the technicalities of it because I want to answer your question.
And these are the last 2 slides.
We're almost done. So when the court signs the order saying their record is sealed, what happens? The pro se client is going to get a certified copy that we tell them to guard their life with, put it in their file. This is the only certified copy. We've had individuals come in the next day, say, hi, my name is John Doe, and I have my record sealed. Can I have a copy? And they say, you don't have a copy. You have no record. It's because it's sealed. That's what they're supposed to say. But that's why it's really important that they keep that certified copy. It's the only certified copy that they're going to have unless they want to pay for more. Alyssa, who works at the clinic, is then going to make 8, 9, 10 copies of that order and resend it to all those agencies. And what this order is saying is that these agencies have to seal those records. So once that is processed, no one should be able to go to any of those agencies and find that record. So it's really important that that order is signed by the judge and being sent off to all those different agencies. Now it can, yes ma'am?
When you send to the agency, is just by regular first-class mail or certified mail or what?
A lot of the agencies, they are going to be served personally. Other agencies, you can just send it by mail. If you have doubts that they're going to get it though, you may want to just deliver it personally. However, for WSP and JRA, they're going to be mailing those. So we mail all of ours out and then personally give the prosecutors and everyone that's in our general vicinity theirs.
Do you use normal postage or a certified mail?
For the ones being sent to the Washington State Patrol, certified mail, I believe that's what we had worked with you. And I believe that's also in the sealing rules for it, is that Washington State Patrol is going to want a certified copy. So if the pro se client wants to keep a copy, then they need to get 2 certified. It depends on the court how much they're going to charge you. We do it a little different in King County. So we send them a copy of the certified copy, and we let them keep the certified copy. We've never had any issues with it. But if you talk to a lot of different offices, they'll say we always send that certified copy to the Washington State Patrol just to double check. So you can always call the Washington State Patrol and ask them exactly what they want. We've been kind of told different things, and so we've just been doing it this route. So once those agencies have that information, that order, and it's sealed, they seal their records. And so to follow up with your question, private companies can take up to 2 to 3 months to update their databases because they're paying for it. So they like to drag that out sometimes. So these companies will, let's say I got my record sealed July 1st. In September, say July, August, September, it still may not be sealed. And it may not be till October until that agency stops giving out that individual's record. It's really important to tell people, and that's why you always want to get people's records sealed ASAP, is because the whole process can take a few months. And if an individual knows they really want a job, but they want to be able to say that they have never been convicted, I tell them wait 3 months. That's probably the best bet to make sure that you're not saying I've never been convicted and having it pop up. However, individuals will have their order signed so that they could bring it to an employer if they're willing to give them a chance and tell them this record is sealed, it's been sealed by the court, I'm legally allowed to say that I've never been convicted of anything. Did that answer your question? Yeah, okay. With that leeway, I'll pass it back off to George, and he'll finish this up.
So we're going to just talk about what it means to have your record sealed in practice. Here's the language. This is RCW 1350. Thereafter meaning after the judge has signed the order sealing the record, the proceedings in the case shall be treated as if they never occurred, and the subject of the records, that's the pro se client, may reply accordingly to any inquiry about the events, records of which are sealed. Any agency shall reply to an inquiry concerning confidential or sealed records that records are confidential and no information can be given about the existence or non-existence of records concerning an individual. Okay? Legislature just can't write anything simple, can they? Okay. So you go into your job interview, and the first question that comes up is, have you ever been convicted of a crime? Your record has been sealed as a juvenile. What can you answer? No. Right? Because you are the subject, and it is treated as if they never occurred. Practically, what's going to happen? You're going to get that job at Microsoft or at Genetics, and you're going to be working, and you're going to be doing great work now, right? And they're going to say, you know, every time we hire someone, we've got to do a background check. And they're going to go, and they're going to reach one of those either major credit reporting bureaus or one of those subsidiaries, and they're going to come back, and it's going to show your criminal history. Why is it going to show that? Pardon me? Well, let's say it's been 6 months. It's still going to show, right? It's going to show because this law was written 10 years, 20 years before anyone ever thought of the internet, before anyone had any idea that our courts would be selling juvenile records to credit reporting bureaus. Right? This law was passed in 1977, I think, the Juvenile Justice Act. And in those days, this was really secure because it only existed in paper files in the courthouse. And it was sealed, no one could see it. So, what are we doing? Why are we doing this?
No, there is a way. There is a way to clear your credit.
There is a way to clear your credit with the credit reporting bureaus. But you can't get those secondary reporters, the ones who bought the records from the credit reporting bureaus, because they're under no obligation to update their data banks. And 2 years ago, the legislature called in the lobbyist for the credit reporting bureaus. She flew in from D.C., and they frankly asked her. They said, what can I find out? And she said, depending on what you pay, we can find out anything about you. The more you want to pay, we can find sealed records. They know how to do it. They know how to mine the internet. So you can't hide it. Now, most of the people who are coming to our clinics have a specific need to get their records sealed because they went down to Wendy's, they went to the public housing, and they were told, we can give you this if you get that record sealed. So they know the existence. All they need is you to come with that certified copy and show it to them, and then you'll get that house, you'll get that apartment, you'll get that job. You'll get into the military, because the military can find out all this stuff, but if you can show them, and why is that important? Why is it important for them to know that your record's been sealed? Because of the eligibility criteria. They know you have no pending matters. They know that you paid all your restitution, so you're responsible. They know you haven't committed any offense for 2 or 5 years. That's what they want to know. They want to know that you've got good character. That's why we're doing this, because we can't hide. I even went to what's that website, Reputation? There's a website where they guarantee that they can clear the internet of all your bad posts or something. It doesn't work. It doesn't touch Facebook or anything like that anyway. But you can't do it. You just can't. So what do you do when you go down to that job and you're interviewing at Microsoft? And they said, on the application, it says, have you ever been convicted of a crime? What are you going to do? Let me give you a suggestion of what you might want to tell your client. You might want to tell them, and this is, I've seen this one, is you put a little asterisk if you're filling it out, or you tell them, I'd like to talk to you about this. And you let them know that you do, but it's been sealed. And usually that is enough, because you'll explain the background. You don't go into, I didn't do it, I never did it. I've complied, I have basically what's the adult called their certificate of rehabilitation. I've complied with everything, and now I am good. Okay? But you can't hide it. And I don't know how many former offenders I've seen who have been hired, who get the background check 6 months, 8 months into their job. They're doing fine, the boss comes by and says, you lied, I have to fire you, you're being crazy. So you don't want to counsel them to do that. But as I say, most of the people that we'll be working with have a specific need, and they need to get this done, and they need to get it done before they can get that job.
So you're saying if someone is applying for a job and they do a criminal background check and a financial check, then
Well,
they're toast?
when you do a background check, they give you everything they have. And unfortunately, as for people who live in Washington, they have free access to all criminal data. We sell it to them. We make money selling our court records. I think we're one of 6 states that do this. Nobody else does this. Most states would think this is an anathema. I mean, most states try to protect kids. I'm not sure where they got the idea that we should, handicap. Where it really becomes apparent is when you apply for that out-of-state position with an application to a college. So you apply to Oregon or you apply to Montana, and they can pull up your criminal history. In Montana, criminal history is expunged at 18 or whenever you finish probation. So you're handicapped versus a student in Montana. I mean, it doesn't make a lot of sense, but we do it. Now, there are groups that are working in the legislature trying to change this, but there's great resistance, especially from the credit reporting bureaus. So here's what the statute says. But beware, sealed records may be viewed by, of course, prosecutors have access to it. The police have access to it. The FBI has it. Court clerks have it. And let's say that the court clerk acknowledges that someone calls up and says, hey, I'm thinking of renting an apartment to Jane. Does she have a criminal history? And the court clerk says, oh yeah, but it's sealed. Okay? She can't do that because we know they have to say they can't acknowledge the existence or non-existence, but they do. Any recourse against that clerk? No. No, you have no tort action. There's no action against them. And a new juvenile or adult felony charge will unseal the record. Okay, so you're 19, you just had your juvenile record charged, you get popped the next day for a DUI. Will that unseal your record? No, it's a misdemeanor. But you get popped for possession of cocaine or methamphetamine, yeah. And it'll also enhance your adult. The reason it gets unsealed is so that they can give you more time as an adult based on your criminal history. Sealed records may still show up, and I explained to you how they do it. It's because of this redistribution by the credit reporting bureaus. And to be honest, I think that woman was very honest when she talked to the legislature. They don't release that data unless you pay for it. And it's sort of obnoxious But again, there's no recourse against them. Okay, we just want to, just real briefly here, guns. If you're convicted of a felony, whether an adult or a juvenile, even if you're convicted of a non-assaultive felony, so you're convicted of stealing a car, okay? Drug charge. Well, let's just missed it. You lose the right to possess a firearm. Now, out here, it's probably a lot more important for people to possess firearms because there's a more of a hunting culture out here than it is back in Seattle. So we don't restore gun rights. And I think your clinic's going to have to make the decision whether you're going to do that service or not. But you have to tell people up front because people will come to the clinic saying, you know, my dad just bought me a new rifle and we want to go out hunting and I can't buy a gun because of this letter I got from the court telling me that I can't lawfully possess a firearm until my rights are restored. So now someone asked me the very good question. What was that question? Can I get a hunting license and go into bow season, bow and arrow season? Can I do that? Sure. All it says is that you can't possess a firearm. Now, how do you restore your gun rights? We have a form that's used. It's not a real tricky thing, but it is discretionary. But we don't do it. We refer our pro se clients to private attorneys. Again, most of the people who are coming to you have a specific need, and it's not to go hunting. It's more to get a job and get employment. So that will come up. Yes, sir.
Is that the same for voting rights?
No. Juveniles never lose their voting. Juveniles convicted as juveniles don't lose their right to vote. It's not, you don't have to restore them. As adults, you have to restore them. You have to finish a term, and then it's automatically restored now because of the recent legislation. But no, juveniles never lose. Juveniles have none of the other disabilities that adults do. You don't lose any civil rights. That's one difference between a conviction and adjudication. But you do lose your right to possess a firearm. So we're going to take a break. If any of you would like to come back, we're going to do some role plays where we're actually going to look at intake forms, criminal history, and you're going to generate the forms. So we'll be doing that. Why don't we take a 15-minute break? When I taught, I never taught for 2 hours straight. You're incredible at that.